Welcome to Looking at Legal Stuff. Today we have a motion for contempt in a case with a couple where dad claims mom has taken their child and moved out of state without getting his permission. He claims he was fine with them moving, he just wanted mom to do it properly through the courts. He says he discovered they had gone ahead with the move when he turned up for his visitation on Thanksgiving and they were already gone. He says he only wanted the chance to say goodbye properly to his daughter. Mom says she thought she had filed the proper paperwork and she had no idea that Dad wasn't okay with things. She said she had no choice but to move in with her parents because she was unable to pay for the mortgage on their marital home after they split up due to DV. What will a judge think of her choices? Let's find out.
Next, I have Caitlin Dalton and Ryan Dalton. Cause number is 23-3-10108. Caitlin Dalton, are you here today? Caitlin Dalton? All right, not hearing a response from Caitlin Dalton. I'll ask.
Yes, I'm here.
Oh,
Sorry.
okay, great. All right, thank you, Ms. Dalton. All right, and Ms. Dalton, it looks like there's a different name on your Zoom page. Do you prefer that I use a different name?
Either one is fine.
And then if I were to use the one that's on your screen, how do you pronounce that?
Teely.
Teely.
Mm-hmm.
All right, thank you, Ms. Teely. And then Ryan Dalton, are you on the line today?
Yes, sir.
Okay, all right, welcome to both of you. We're here on a motion brought by Mr. Dalton for contempt. So let me just double check. Ms. Dalton, did you receive the documents that were filed by Mr. Dalton, or pardon, Ms. Teely, did you receive the documents filed by Mr. Dalton related to the contempt motion?
Yes.
Okay. And let me double check. Did you, Ms. Teely, file anything in response?
No.
Okay. And let me check with both parties. Mr. Dalton, are you looking to proceed with the motion for contempt today?
Yes, sir.
And Ms. Teely, are you wanting to move forward today with the contempt motion?
I would like to say my part of it.
Okay, that's
yeah.
fine. That's fine.
Okay.
Yeah, you'll generally the way we do that is the moving party, the party who's asking for the contempt will go first, and then you would have an opportunity to hear what he has to say, and then you would speak your piece and say what you believe to be true and accurate. Then we'll turn the time back to Mr. Dalton, because this would be the first time for him to hear what you're saying, and he would need an opportunity to respond to that. Since you know what he's going to say, so you have an opportunity to respond to what he has to say. You also have the opportunity to share different viewpoints or new information, and then he would have the additional opportunity to respond. So that's the order. Mr. Dalton would go first with his comments, then you'd go second, and then Mr. Dalton would go third.
Okay.
All right, so with that kind of under our belts, I'll turn the time to Mr. Dalton. Mr. Dalton?
Yes, Your Honor. So kind of what's happened is I received back in June, I'm sorry, a denial for immediate order on motion to move with children. It went through and was denied. And then in October, that Kate filed. And then in October, I received more paperwork in regards to a similar motion that was not filed through the court, but it was all the documentation leading up to wanting the motion to move. So I went multiple times to the courthouse to try and respond to that paperwork. But every time I came in, they were like, nothing has been filed. This is the first we've known of it, et cetera, et cetera. All we have on file is the denial. And I stressed after the third time coming in that I would like to do something to stop her from being able to leave the state until we had due process and everything was done legitimately, as well as talking to our mediator, which is her father, and pleading with him as well to not allow her to leave the state without us having everything done. I know there was a time constraint and I was fully willing to work with that. I told her dad, I said, I could do mediation from any point. Like, we can work with a time crunch. We could do whatever we want and need to do. I just want it on paper, and I want a judge to sign it, and just do it right. And I started paying child support as soon as April. I had the child support for November in my hand on the day that I was going to pick up my daughter, which was the Friday after Thanksgiving, to have my Thanksgiving opportunity with my daughter. And I found out that morning that she was no longer in the state of Washington. She uprooted my daughter to Colorado, which is a pretty big deal. I tried everything I could. I called the sheriff's department. And the best that I could do was file this contempt order. Like I said, I wasn't trying to say no to her leaving. I just wanted to do it right, because me and her have both been through this before with her ex. And I just wanted to make sure that my daughter knew when I'd see her, and when I wanted everything to be to where we could both be there, and I could say goodbye to my daughter and tell her when she was going to see her dad next. And that didn't happen.
Can I ask you a question? So
Yes.
So where is your daughter living now?
She's in Colorado with her mom.
How long has she been in Colorado?
Sometime the week prior to Thanksgiving, sir.
So, and
I had no knowledge of any of it.
were you ever served with a notice of intended move or intended relocation or move of the child?
Yes, sir. Like I said, in October. And when I got that, I went to the courthouse 3 times to respond to that document. And
what case was that filed in? Because I'm looking at this case and I don't see anything filed related to
exactly, Your Honor. She didn't file it. That's where there was the hiccup.
Oh. Okay.
One was filed and denied in June.
Right, I see that.
And then she sent me full documentation. I have it all right here. Sorry, I have all the documentation right here. I know it's hard for you to see, but I could bring this in and I can get this to you. That's not a problem. But it was never.
Hold it up again and just show me like the title on the right side top. Okay, so that's the document that was given to you but was not filed with the court.
Yes, and I went in 3 individual times after her dad, because our mediator, about trying to not allow this to happen until we went through the due process, which didn't happen.
Okay, and so your contention is that Ms. Teely violated a court order that by moving with the child to a different state without notice to you.
Without notice to me, without a parenting plan, with nothing. I mean, no real prior knowledge of any of it.
Or even without court authorization.
Yes, sir.
Okay. All right. Ms. Teely, I'll hear from you.
Okay. So I would like to start by saying I never wanted to prevent Piper, our daughter, from seeing her dad. What led to me having to relocate was a whole set of circumstances, but I want to say I did consult with 2 attorneys prior to ever trying to relocate. The first relocation that Ryan Dalton is referring to that was made in June was in regards to a different move entirely. So that's, I feel, irrelevant in this case. And then as far as this
Can I ask you a question about that, Ms. Teely?
Mm-hmm.
So the June 12, 2023 order is where you were asking to move, and I don't know where, but you're asking to move to relocate, and that was denied, meaning you cannot move. And then it's in the order, it reads there were no valid reasons to allow the children to move before the other party's deadline to object to the move. Further, it says you need to serve notice of the move and note to a docket if the house sale is imminent. So that's the order you're talking about in June, right?
Yes. Can I just go back to the beginning of what led to all this?
Well,
In
let me,
March
if you don't mind, I'll allow you to do that, but just one pressing question, and then I'll allow you to go in that direction.
Okay.
So the child is living in Colorado with you now,
Yes.
and did you file a notice of intent to relocate?
No, there was no ordered parenting plan. We only had a temporary parenting plan in place because of a protection order that I had to take out against Ryan Dalton.
The protection order, which is a 2023 case, it says visitation is allowed every other weekend or as ordered under the family law case, which is our family law case we're talking about here now. So there, it specifically orders every other weekend visitation.
Okay.
Has that occurred?
It was occurring until I had to leave.
Okay. And so then if the court is ordering every other weekend's visitation between father and daughter, and there's a motion for contempt related to that and also the move, what's your position?
Back in March of 2023, Ryan Dalton assaulted me in front of our daughter. Prior to this, I was a stay-at-home mom and homemaker. When the assault happened, Piper and I had to seek shelter in a domestic violence shelter. We stayed there for a week. Ryan Dalton was asked to leave our home that we owned at the time by sheriffs so that Piper and I could return to the home, at which point we did after a week of staying in the domestic violence shelter. And at which point we had to proceed with selling the house because I couldn't keep the mortgage. I had no income of my own. So the motion for relocation that I'm sorry for being upset. The motion for relocation that I originally filed with the court in June was to allow for a move from our home on Abernathy Creek Road into town into an apartment that I could afford for my daughter and I. So once I made that move into town, I had no choice but to make the move. The house was sold. I couldn't make the payments. And I stayed in that apartment. I had no family in Longview. I have no friends in Longview. I was on TANF to help pay bills and food stamps to put food on the table. I spent 5 months there trying to keep work and our home for Piper and I. I did everything I could to ensure that Ryan Dalton saw his daughter. I want them to have a relationship. This move was not to take her away from him. It was because I couldn't afford my rent anymore. I had no help with Piper. I couldn't hold down a job because I had no childcare. I had no help with Piper. Piper kept getting sick over this time frame. So I consulted with 2 separate attorneys asking them what I need to do to remedy my situation. And they told me to fill out and serve him with the notice of intent to move with children. And I did that to the best of my ability. I consulted with them both, told them all the steps I was taking, and I thought I had taken the right steps. I waited the 30-day objection period to hear from Ryan Dalton that he objected to our move. I didn't hear anything. I tried my hardest to make sure I was following the law and abiding by the law. The attorneys told me that I was free to move because I couldn't provide for my daughter there. I'm living with my parents here in Colorado. My mom came and got me around Thanksgiving because I had tried to stay there. I didn't want to rock the boat or cause trouble by leaving, but I had no choice. I couldn't pay the bills anymore.
Okay. All right. Any additional information, Ms. Taylor, you'd like to share?
I sent Ryan Dalton the notice of intent to move in certified mail. I have a return receipt As you saw, he has the documents. We were in court last week with a motion to modify our protection order. I had made that motion in order to accommodate mediation so that we could come up with a parenting plan. And at this point, I want Piper to see her dad. I just want to stop the fighting. This has turned my life upside down, and I've been doing the best I can to provide for my daughter and I, and this isn't helping anything. I want Piper to see her dad.
Thank you. Let me ask you one question. There's a specific allegation Mr. Dalton makes. He says that there was not a visit on November 24th, which was the weekend, I believe, of Thanksgiving. So my question is, was there a pattern of visits that was occurring under the guidance of the restraining order, that every other weekend that we had talked about before?
Yes. And we also, through my dad communicating with him, we did ask him if he wanted to have additional time with Piper around Thanksgiving. And he had said no, he didn't.
So that weekend of the Friday is the 24th of November. Under that every other weekend, would that have normally been Mr. Dalton's time for visitation?
Yes, it would have. But from my understanding, the way the whole thing went down was that he had the 30-day objection period that he didn't raise an objection to. So I thought I was in the right to go ahead and make that move from what I understood about it.
Okay. All right. Mr. Dalton, anything in reply? Oh, Mr. Dalton, I apologize. It looks like you're muted.
Sorry, sir. Can you hear me now, sir?
Yes.
So, regarding Thanksgiving, my scheduled day was Friday to Sunday. Mind you, I live in Seaside, Oregon, and I for one reason or another, I didn't get to see my daughter till the week prior to Father's Day when I started seeing her. So then after that, it was every other weekend, and I drove to and from, which is a 3-hour round trip drive, to visit and see my daughter, pick her up and drop her off. I had no assistance in that at all. But on the Friday after Thanksgiving, when I was supposed to have my daughter, I had my child support checks in hand, literally I drove to Longview just to find out that my daughter was no longer in the state. And in that time, I've not only missed Thanksgiving, I missed her birthday, I missed Christmas, I missed New Year's. I filed everything as I could. And as far as not responding to the 30-day notice, I went in 3 times, and I not only did I go in 3 times and was refused response because there's nothing to respond to in the court's eyes, I pleaded with her father for the course of the 3 weeks that this was going on that she did not go about it the right way. I literally was trying to, I was basically giving her everything she was requesting. I just wanted it done through the courts. I wanted a judge's signature. I wanted the divorce done. I wanted a parenting plan. Like I said, I wanted to be able to go to the airport, give my daughter a hug, tell her I love her, and tell her when she's going to see me next. And that was stripped from me. Like I've said, I missed her birthday, holidays. And at this point, the other thing that perturbs me is that I am more than capable of having my daughter, Your Honor. I've held down a job. She was a stay-at-home mom due to me working full-time. Not only that, I could have been more than capable to take my daughter for the time being. I would never try to take my daughter from her mom. She needs her mom. She needs both of her parents in her life. But I would have been more than happy to take my daughter during this rough time in her life, let her get back on her feet, and then, she could start having parenting visits and et cetera, et cetera. I think due to her past relationship and her ex situation, she tried to not allow that. And with that being said, I mean, and I told her parents, I said, not only are you taking in your daughter, but you're also taking in mine. And that was without my consent. I'm more than capable of having my daughter, taking care of my daughter, not asking for child support, not asking for anything, just let her mom get back on her feet and go from there. But I was never given the opportunity. Like I said, as far as the response goes, I literally have text conversations, paragraph conversations with her father, pleading him, hey, she did not go about this the right way. Don't let it happen. I'm willing to work with you, time crunch, et cetera, et cetera. I mean, at this point, the protection order is 2 months away from being over. She's 1,700 miles away. So that doesn't, a modification that we went to last week should have just been a complete dismissal, in my opinion, so that we could move forward. I did everything I could, Your Honor, to accommodate this move, but they just went about it the wrong way. And all I'm asking for is now I'm having to go through this battle. I agree with her. I don't want to fight. There's nothing to fight about. Everything's already been, we've been separated for going on a year. I mean, at this point, it could have been a simple mediation, adjust child support, adjust the parenting plan, come up with a strategy, sign, seal, deliver, and have been done with it. But they refused to listen to me because I like I said, I went to the courts 3 times and tried to respond to this, and the courts wouldn't even allow me to respond because there was nothing technically to respond to.
Okay. All right. Thank you.
Could I say something in response?
Briefly.
The only response that we got from Ryan Dalton, we did not get anything until after the 30-day rejection period. He did not acknowledge that he received the notice of intent to move or anything until right around Thanksgiving, which at that point is when he finally said all those things. So it's not like he was pleading for us to not leave and we just left anyways. We didn't even get those until we were actually out of the state.
Okay. All right. Thank you.
That's not
right.
true, Your Honor.
I'm ready. I've heard from the parties. So there's a motion for contempt that's filed by Mr. Dalton that alleges that his parenting time was denied. So this case it's not quite as straightforward as an average contempt, in that there's not a temporary parenting plan in place in the family law case. That's the case we're in here today. However, there is the protection order in the criminal matter that specifically references this family law case. That order is effective until sometime in March of this year. And it specifically allowed visitation every other weekend of Mr. Dalton and the minor child. And so the parties acted upon that, and there was apparently a visitation schedule that was set up, and Mr. Dalton was exercising that visitation, and it was kind of on this every other weekend. And the specific allegation in the motion for contempt is that on the weekend of the 24th of November, that visitation was denied. So I look at a couple of different things here. One, I look at the family law case. There's not a specific provision that establishes it. However, there's a restraining order, a criminal matter, that makes specific reference to the family law case and specifically orders for visitation to occur on an alternating week basis. So also is important to note that the notice of intended relocation was never filed with the court. So when parties initiate litigation, they necessarily involve a third party, the court. And when any party wants to do something, generally it's under the supervision or auspices of the court. Here, while Ms. Thiele apparently gave a notice of an intended relocation to Mr. Dalton, the court was never apprised of that. And so when Mr. Dalton apparently tried to respond to that, he couldn't because nothing had been filed. And so any action that takes place needs to be under the supervision of the court. That way, everybody knows what's going on. And if there's discrepancies or concerns, they can come to the court and argue their point to the court. So the visitation on November 24th did not occur. And so based on that, I will make a finding of contempt that Ms. Thiele violated a court order by denying that visitation. And I recognize there's a lot of extenuating circumstances involving divorce, relocation, job, finances, ability to care for a child, a safe place to be, having an apartment or a place to feel safe. I recognize that, and that's compelling information. However, the court had ordered an every other weekend visitation, and that did not occur. So I'll grant the motion for contempt, finding that Ms. Thiele willfully violated that provision in the restraining order that makes reference to the parenting plan. I think where the parties are at now. So as far as a purge condition, in order to purge that finding of contempt, Ms. Thiele can purge that by allowing for visitation to occur on that alternating weekend basis. I think here in the future, there needs to be a parenting plan established. So either party is free to bring a motion to establish a temporary parenting plan. And I think there needs to be some guidance set up there, and we need to hear from both parties. So either party can initiate that motion for a temporary parenting plan. So there can be a little more order and potential guidance for the parties as far as the custody and visitation of the minor child. So I will prepare an order on contempt, and I'll file that with the court later today. And then the parties, if you need a copy of that, you can contact the clerk's office and check with them, and they can get you a copy. So that's kind of where we're at today. So that's my ruling. Does anybody have any questions?
Yes.
Go ahead, Ms. Dalton.
As I had already stated, I motioned for a modification of the protection order in order to do mediation so we could come up with a parenting plan. Is that not sufficient for, asking the court to come up with a parenting plan for us?
So mediation is separate and apart from the court. It's encouraged by the court to have the parties mediate to see if the parties can come to an agreement. If the parties can come to an agreement, then the general course is that the parties would prepare an agreed order, submit it to the court, and say, we both agree, this is what we want, and the court would sign off on it if it seems appropriate. However, if the mediation is ongoing or is unresolved, then any party's free to bring a motion for a temporary parenting plan, notwithstanding mediation is permitted by that other order that you were mentioning. So it's kind of a dual track. We as a general rule, we want to resolve cases, and if cases can be resolved through mediation, fantastic. If they can't be resolved, then come to court, fantastic. But the idea is to resolve cases. So the mediation, that's permitted. The parties are encouraged to do that. And if after engaging in that mediation that there's not an agreement, then the parties would come to court and ask the court to make a decision.
Okay, it's just since I'm in contempt of court and there's no way for me to get Piper to see him. I don't understand what I'm supposed to do. It just doesn't seem fair. I was doing the best I could as a single mom. This is like a result of his actions.
No, and I recognize there's a lot of different factors that go into this, and like I said, from a emotional standpoint, very challenging circumstances. So the contempt is I've made that finding. Sometimes people can purge their contempt. Other times they cannot purge their contempt, and then that would move to the next step which would be mediation. If the parties agree, great. If they can't, then there'd be a motion for temporary orders.
So I just I don't even understand what it means to be in contempt of court if I have repercussions or something happens to me about it. And like I said, I'm already trying to facilitate a relationship between Piper and her dad by requesting I can't contact him and he can't contact me. So the only way we could do that is through mediation, and the protection order doesn't allow that. So that's why I made that motion. I just don't, I'm not in contempt of court. I'm trying to work with him.
So I'll file that, the contempt order, and then I'll allow the parties to proceed as they deem fit. That'll conclude today's hearing. Thank you.
Your Honor, can I say one thing?
Yes, go ahead.
As far as everything goes, I mean, mediation is the end goal. Like I said, that's what I wanted from the get-go before everything happened. With that being said, as far as trying to see my child, what's going to be the best course of action for that? Like, because I know that it's going to be about anywhere from $1,000 to $1,500 to fly her out unsupervised. Me and her have both been through this, Your Honor, and it's one of those things where I deserve to see my kid, and that was taken away from me, and now I'm just trying to figure out how I can do that best. And I agree. I am going to file. Mediation would be ideal, and that's really all I was going for from the start of this. With the whole contempt thing, is just let's do it the right way.
Okay. All right. So I'll file that order of contempt, and then the parties, if the motion to modify the restraining order allows for mediation, then the parties can seek mediation. And if that doesn't work, then the parties can seek a motion for a temporary parenting plan.
Is there any way that we could just dismiss that protection order so we can get this started?
So the no contact order is in effect until sometime in March of 2024. If any party wants to modify or terminate that, they're free to file a motion to seeking that dismissal or modification, just as Ms. Thiele has sought modification of that restraining order. Any party can file a motion to drop or modify.
Yes, sir. I understand. And I know we have a court date set for the 22nd to come back on that. Means how we're just a couple months out. I would just like to advise Kate to just drop it and let's start mediating as soon as possible.
So we'll need to wait for that hearing date to come, and we can address it at that time. And then if it's granted, then mediation can ensue thereafter.
Yes, sir. Thank you, Your Honor.
All right. That'll conclude today's hearing. Thanks to each party.
Thank you.
The next matter I have is Emily Wood and Michael Wood. The cause number is 233148-08. I see